everyone. I'm Jenn Dickey, Associate Chief Counsel at the U.S. Chamber Litigation Center, and you're listening to the U.S. Chamber of Commerce Institute for Legal Reform's Cause for Action podcast. On today's episode, I'm joined by Archis Parasharami, a litigation partner at Mayer Brown. Archis is one of the nation's leading lawyers specializing in consumer litigation and class actions. He's also the author, or one of the authors, of a paper recently released by ILR, TransUnion and Concrete Harm 1 Year Later. Today, we'll be talking about the U.S. Supreme Court's decision in TransUnion and that impact. Thank you for joining us today, Archis.
Thanks for having me. It's great to be here.
First, can you give us an overview on why people should care about the TransUnion decision?
Yeah, absolutely. It's a great question. There's an old saying, don't make a federal case out of it. And it made me, when I was thinking about the TransUnion case, think about that phrase. So in planning for our talk today, I looked it up, and it turns out that the online Merriam-Webster dictionary actually defines this idiom, make a federal case out of, to mean to become very upset or angry about, parentheses, something that is not important. I think that neatly captures actually what TransUnion is all about. When does a perceived harm matter enough to allow someone to open the courthouse doors and bring a lawsuit? And so that question and the answer to that question matters hugely to lawyers who spend their time bringing and defending class action lawsuits. It matters to businesses that must defend themselves in those cases. And I think actually it should matter to all Americans, because people generally certainly should have a right to pursue claims about injuries that are real. But businesses, including small businesses that are owned by a few people and large businesses that are owned by shareholders, should not be forced into litigation over claimed harms that aren't real. And I think that this is something that I think is core to the chamber, that lawsuits that aren't meritorious impose massive economic, social, and personal costs. And that's something I agree with. And that was the troublesome phenomenon that TransUnion addresses. And so I think the basic point of TransUnion is to explain how to tell the difference between when an asserted injury is sufficiently concrete, that is real enough to allow a plaintiff to sue, and when an injury is at least legally harmless. And knowing the difference is often the distinction between a lawsuit that proceeds and a lawsuit that should fail.
That's really interesting. I think it's important to note sort of right off the bat that TransUnion involved both a named plaintiff with a particular allegation of harm or injury, something that particularly made them kind of make a federal case out of it, and a bunch of unnamed class members who probably didn't even know about the class action at all, to the extent that they, received a notice. They may not have paid any attention to it. So can you, I guess let's start from the beginning. You talked a little bit about what harm is. Can you explain a little bit about no injury class actions and the conflicts that they're bringing to the courts?
Yeah, it's a great question. And I think your point is critical, that these issues have largely, though not entirely, been litigated in the class action context. And that's because the class action is what makes these claims consequential. My hope is that this no injury class action issue is a problem that is hopefully on the way out. Congress has passed many, many laws that include statutory damages provisions. These are inherently, in my view, okay. There's not a problem with having statutory damages provisions. Their goal is to encourage individuals and, frankly, their lawyers to bring claims that have relatively little value, to encourage the person who has been actually harmed by a violation of law for which it's hard to quantify the damages to sue. That can still present a problem in individual cases when it comes to standing if the plaintiff hasn't really been injured, and we'll talk about what that means, I'm sure. But in practical terms, it's not a huge deal, because no matter what, we're not talking about a lot of money, and small claims typically settle. But when it comes to class actions, it's a whole different ballgame. Statutory damages claims are often aggregated in class actions. And so a claim that was a $1,000 claim, let's say, for statutory damages, can quickly be transformed to potential exposure of hundreds of millions of dollars, maybe even billions of dollars. And that seems highly troublesome if the reality is that either no one or almost no one in the class has been harmed. And so that really was sort of the backdrop, the historical backdrop that led to a number of Supreme Court cases, including TransUnion and its predecessor, Spokio, on standing.
So I guess we should go back to Spokio because it's really hard to understand TransUnion without looking back to Spokio. Spokio Inc. versus Robbins in 2015, the plaintiff alleged that Spokio had failed to undertake reasonable efforts to ensure the accuracy of information appearing about him on its site. Interestingly, if I remember correctly, he was objecting to the fact that the information was more favorable about him on its site than the reality. Like it said he was really wealthy, and in fact he was not. Can you explain a little bit more about this case and how it changed the trajectory on these no injury class actions?
Yeah, it was a terrific case. Full disclosure, my colleagues and I litigated the case. One of my partners litigated it in the district court and actually spotted the standing issue from the start, and our firm litigated it all the way to the Supreme Court. And I think what you said is right, that this case illustrates a potential problem where somebody hasn't been harmed but claims a bare statutory violation. So Spokio was a putative class action under the Fair Credit Reporting Act. The statute imposes obligations on consumer reporting agencies. You think something like TransUnion or Equifax or Experian with respect to the consumer information that they provide. Spokio is a people search engine. It denied that it was a consumer reporting agency, but before it even got to that point in the litigation of whether it was or wasn't a consumer reporting agency, there was this question of standing. So Mr. Robbins alleged, as you said, that Spokio was violating the Fair Credit Reporting Act because, according to him, the company did not take reasonable procedures to assure maximum possible accuracy of the information concerning him. And that the language I described is what's in the statute. The statute requires those reasonable procedures. He sought statutory damages for alleged violations of FCRA. To my recollection, he didn't seek actual damages, and I think from our perspective, it was because he had none. And you nicely alluded to the inaccurate information. According to him, the problem was that that Spokio's the results that were displayed on Spokio suggested that he was wealthier, more educated, and that he was married when he was single. Notably, he didn't claim any specific harms from this, other than an assertion backed up by no evidence or specific allegations that he had diminished employment prospects. I think Justice Sotomayor at the oral argument talked about whether he might have faced a problem on the dating apps if somebody thought he was falsely advertising himself as single when he was married. He didn't allege that in the complaint. So that may have been a different case. That wasn't the case brought to the Supreme Court. What was brought to the Supreme Court was, can Congress confer standing on plaintiffs by creating a private right of action for a bare statutory violation? In other words, whether or not he was harmed in real life in some concrete way, like he said, this is a job I can't get, or on the apps example, this was a date I was rejected by. Even you could debate whether or not that is concrete enough, but in any event, he didn't argue for that as strongly as he argued that the mere failure to engage in the reasonable procedures to assure maximum possible accuracy was in and of itself enough to sue. And why did he do that? Why was he taking this kind of narrow approach instead of talking about his, if any, real problems in order to bring a class action? That's really part of the story, is that there may be people who are injured by statutory violations because some consequences flowed from that violation, but it's harder to have a class action in that context, because then everybody has to come forward and show their harms, and it turns out that many people often aren't really harmed. But if all you need to do is say, here is the error in compliance with the statute, that can often be a lot easier to show because there aren't variations in harms or variations in damages. So that was the backdrop of Spokio, and I'd be happy to kind of talk through what the court did.
Well, I think you can give us the sort of the bottom line of Spokio, because the bottom line of Spokio is really the starting line of TransUnion.
Yeah, I think that's exactly right. The court ruled for Spokio by a 6-2 vote in an opinion by Justice Alito. The opinion was issued in 2016. Between the oral argument and the decision date, Justice Scalia had passed away in February of 2016, and that left an 8-justice court at the time. And I do think, although it's hard to know for sure, that may have led to some compromises in how the opinion was put together. But what the court held was nonetheless a victory for Spokio. The court held that Congress cannot erase Article 3's standing requirements by granting the right to sue to a plaintiff who would not otherwise have standing. And the court made clear that a bare violation of a statute is not enough. Even in the context of a statutory violation, Article 3 standing requires a concrete injury. And I think the part that really flowed forward into TransUnion was when the court held that a plaintiff must show that his or her alleged injury actually exists and that it is real and not abstract. I think, real is another word of saying concrete, but it underscores that it can't be a pure statutory violation alone.
Yeah, you want it to happen in the real world.
Yeah.
Something out there with facts that you can say, this harmed me. I think the interesting thing about Spokio is a lot of times when the Supreme Court decides a case, you think, oh, it's resolved the issue, we can move on. But I think everyone knew when Spokio was out that it didn't resolve the issue, that there was a lot of sort of room left on the table for arguments. They hadn't sort of gone into what it is to be a concrete injury. And, your paper, really, really well described sort of what happened afterwards, with lots of cases disagreeing about what it meant to be concrete and whether Spokio, applied to procedural and substantive violations, all sorts of questions that people had about the scope of Spokio. So that kind of led us to TransUnion, which we sort of already talked briefly about. But TransUnion is sort of the next step. Can you tell us a little bit more about what Spokio meant, what a concrete harm means? What's the bottom line from the Supreme Court in TransUnion?
Yeah, I think it's a terrific question. I agree with your observation that while initially in the wake of Spokio, I think it's fair to say we hoped, defendants hoped that had given the needed clarity for the lower courts to get concrete harm right, certainly from our perspective, to get it right. That is not how it shook out. Instead, what resulted was a good deal of confusion in the lower courts about what Spokio meant. Spokio used the phrase intangible injuries. It referred to procedural violations. And so then some courts, said, well, what's the other side of that? Substantive violations. And some courts said that if Congress had declared that a harm was, quote unquote, substantive, then that was enough for a bare statutory violation resulting in a quote unquote substantive harm based on Congress's judgment to be enough, which essentially in some circuits effectively made Spokio relatively ineffective. And that's what I think led to the conflict that brought us to the TransUnion case. And TransUnion, I think, really answers a number of the questions that were lurking post-Spokio. And I think the most important aspect of it was to, give real guidance, meaningful guidance on what counts as concrete harm within the meaning of Article 3. And it might be worth stepping back just a little bit to talk about what the point of this all is. Where does this concept of harm come from? And I thought that the opinion in TransUnion does a very good job of walking back to the first principles of why do we care about standing? Where is it in the Constitution? And it's a reminder that there are constitutional principles surrounding standing. And so just to step back, Article 3 of the Constitution limits the federal judicial power when the federal courts can act to, quote, cases and, quote, controversies. These are the words that the Supreme Court has recognized must be given meaning They stop the federal courts from acting as an advisory body. Some state courts can provide advisory opinions. That happens in other countries, but the federal courts can't do that. That's been recognized since, I'm going to say, like the 1790s. When there's nothing at stake, the federal courts can't exercise authority. To have something at stake, for the plaintiff to have a personal stake, is what it means for there to be a real case or controversy. And in the opinion...
And I would just interject here, because I do think that people forget that this actually serves important separation of powers principles, right? Which is that, when the founders were drafting the Constitution, they considered a very broad judicial role that involved sort of a negative on any legislative actions, like that they could immediately review every statute passed by Congress and decide if it was consistent with the Constitution. They considered proposals that they would just decide any question of import to the federal government. But that would make the judiciary quite powerful. And the judiciary, of course, in our country is not, the federal judiciary is not responsive to the public insofar as it's not elected. You can't just vote them out. Their salary is, not affected. It's guaranteed for life. And so keeping the judiciary to its role of cases or controversies was an important way that the founders ensured that it was Congress and the president that were responsive to the people, and the judiciary was a more modest role checking Congress and the president.
I think that's right. I mean, I think that the constitutional design is intended to leave policy in the hands of the more political branches, Congress and the executive, and to have the court only decide cases that are genuine cases. When there's a real dispute, then they can act as courts have historically done, as courts in the English common law tradition had done. And when it's more abstract and that's one of the reasons that the Supreme Court doesn't just decide things every day, right? A case has to be brought to it, has to work through the process. And the same is true of the lower courts. They don't, as you say, federal judges aren't walking down the street deciding questions. A litigation has to be brought to them, and it has to be real. The plaintiff has to have a personal stake in the dispute. And that's really at the core of standing, and it's at the core of TransUnion. The phrase the court has used is an injury in fact.
Yeah, so in TransUnion, the court actually went back to some of these historical principles to figure out what's an injury in fact, right? What did you view as the sort of rule that came out of Justice Kavanaugh's opinion for the court?
So, a few points. One, and this was clearly stated, maybe for the first time as directly as he did, but the opinion says that an injury in law is not an injury in fact. So what counts as an injury in fact? Courts are supposed to assess whether the alleged injury to the plaintiff has a close relationship to a harm traditionally recognized as providing a basis for a lawsuit in American courts. And then what does that mean? Have the plaintiffs identified a close historical or common law analog for their asserted injury? It's then, what does that mean exactly? The courts don't have to be tied precisely to what has happened in the past. The opinion says that an exact duplicate in American history and tradition is not required. But at the same time, courts are not authorized to engage in an open-ended invitation to loosen Article III standing requirements based on contemporary evolving beliefs about what kinds of suits should be heard in federal courts. So I think, just to sum up what that means, sometimes it's easy. If somebody is seeking, claims that there's an economic injury, seeking redress for that, that has always been enough when we're talking about money. And once you get past things like money or clear, let's say, violations of property interests, and we're talking about things that are more abstract, in the Spokio court's phrase, intangible, though I feel like that ultimately was a potentially too mushy a phrase for the lower courts to work through. Then you have to engage in this historical analysis, looking at history, looking at the common law. And post-TransUnion, that's what courts have been doing, and it has been outcome determinative, I think.
So that sounds like a positive thing. It sounds like you think TransUnion has so far had benefits in terms of the courts actually, more rigorously enforcing the Article 3 standing requirements. Is that what you would say?
I think absolutely. I mean, and indeed, there are some cases where they turned out one way before TransUnion and another way after, and it was clear that TransUnion was making the difference. Whether they should have turned out the same way, I mean, in my view, I thought Spokio was clear enough, but there are lots of courts that disagreed with that point, and I think that's why it was important for the Supreme Court to step in and resolve these conflicts, and it has made a difference.
Do you think plaintiffs' lawyers will still find a runaround or a workaround to try to get these no injury class actions into the courts?
Yeah, I have. I would say a grudging admiration and respect for our friends on the other side. They are entrepreneurs who are always looking to find ways to bring the claims they want to bring, and so they are looking for ways. And I think what many of them have said publicly is that their best angle is what they would phrase as a "be careful what you wish for," which is that they will now try and plead claims where they assert that there is a lack of Article 3 standing in order to get into state court. So you will sometimes see complaints where the plaintiff literally says, I was not concretely harmed by the statutory violation or some version of that. And their goal is to make it harder for defendants to remove the case to federal court, or if the defendants do, to smooth the path to a remand to state court, because they believe they've fessed up that there is no concrete harm. What I find fascinating about that is that, at least in a literal sense, they have said, my client has no real harm, at least no real harm within the meaning of federal standards. And, to me, that almost gives up the ghost in terms of what it is that the case is about, because then the case is about something other than delivering justice to individuals who have been affirmatively harmed. But be that as it may, I think that this is just, from the vantage point of the tactics of litigation, a chess move by the other side to try and get into state courts that they view as more favorable. I think that there's at least two things that defendants can do to push back. One is that many state courts have affirmatively said that they have the same standards for standing as federal Article 3 standards, and have even gone so far as to say that the Supreme Court's Article 3 cases are persuasive in determining state law standing requirements. So in those courts, and it's not all, but it's many, TransUnion would have the same effect. But I think, and this goes to your separation of powers point, there is an interesting future argument to be made about the role that Article 2 of the Constitution has to play for federal claims in state court. So maybe we can talk about that.
Yeah, I would love to hear your thoughts on this this argument. I know we flagged it, or you flagged it in the paper that ILR recently released, and I think it's a good point for those who are facing these types of class actions in the future.
Yeah, I mean, I think when you talked about separation of powers, there are so many things that this. I mean, it's amazing to think back that so long ago that the framers of the Constitution designed a structure that is really organized to protect liberty, and it does so through the separation of powers, through competition between the branches. And Justice Kavanaugh alluded to this in TransUnion in talking about why Article 2 of the Constitution, which deals with the executive's powers and prerogatives, matter in thinking about Article 3. And so this is essentially the argument that under Article 2, it's the executive's prerogative to act as a public enforcer of federal law. And that is a structural reason to think about concrete harm as allowing only individuals that are personally, privately harmed to sue under federal law. Otherwise, the effect would be to deputize all persons, whether harmed or not, to usurp the role of the executive in being the public enforcer. And so what TransUnion said is to permit Congress to convert the undifferentiated public interest in executive officers' compliance with the law into an individual right that can be vindicated in the courts is to permit Congress to transfer from the president to the courts the chief executive's most important constitutional duty, to take care that the laws be faithfully executed. And, the take care clause, I think, is essentially the constitutional source of prosecutorial discretion. And I mean that in a good way, because my sense is that the government should not, engage in maximum enforcement of laws all the time. And all you have to do is ever drive on a highway to realize that no one wants that, that is, that if you drive 56 miles an hour, that you shouldn't necessarily want that to be, fully enforced at all times, and that there should be some discretion and there should be some restraint. And part of the problem with deputizing private citizens to bring these claims is that there is no restraint, because instead of, a public authority that is, at least in theory, supposed to have the common good in mind when pursuing these, enforcement actions, it's substituted by private enforcers who have economic incentives to maximize the level of enforcement for profit. And I think we're all for profit in some settings, but I think that when it comes to important choices about the enforcement of federal law, that might not be the best place to essentially generate a bounty. So that separation of powers argument is the argument. It's going to play out in state courts, because in federal court, Article 3 really resolves the questions. But in state courts that have broader views of standing, I think some defendants, when it looks like it would be appropriate, should argue that Article 2 places an independent restraint on the enforcement of federal laws in private civil litigation. And that's something that's going to take a while to percolate. I'm not currently aware if that argument has been made. Clearly, the seeds for it are right in the TransUnion opinion, and it will take a while for state courts to look at it. But, long term, I think there's a strong possibility that state Supreme Courts come to different views on the effect of Article 2. And so, I hope one day that the Supreme Court will have the opportunity to weigh in on that issue.
Well, and that's one of the benefits of that argument for defendants who are forced into state court and would prefer to be in federal court but are not. Obviously, laying the groundwork for an Article 2 argument lays the groundwork for potential Supreme Court review, even of U.S. Supreme Court review, even of a state court decision, because a federal question that's resolved definitively by a state court may potentially be reviewable by the U.S. Supreme Court. I think this is actually a good place to potentially wrap up our discussion, because I think you hit on one of the points that the chamber often makes in these cases, which is, when these private enforcers are bringing these suits, they may be thinking about the interests of perhaps even their counsel as opposed to the class members, right? The counsel who sort of generate this class action and work it up, there's going to be benefits for them. But we're not necessarily thinking about the costs to businesses that are eventually passed on to the very consumers who brought the suit in the first place in the form of higher prices, to their employees in the form of lower wages, and to the economy as a whole if businesses are less efficient. And so, that's an important point that we make in these suits all the time. I know you make on behalf of your clients and on behalf of us when you're writing briefs for the chamber. So, I think it's something important to consider, and I urge all of our listeners, if you want to learn more about TransUnion, to read the paper that's on ILR's website, TransUnion and Concrete Harm 1 year later. I think it has a lot of important nuggets, and we'll enjoy talking to you on another occasion. Thank you.
Thanks, Jen.